Hello everyone and welcome to this video. Today I'm back with another interesting topic by the name of res gestae. Now, the doctrine of res gestae is something which many of you might be familiar with. Now, for those who might not be familiar with it, I would like to tell you that res gestae is a concept which we use while dealing with appreciation of evidence under the Indian Evidence Act 1872. Now, evidences can be of many kinds and witnesses can be of many kinds, but res gestae is something which is an exception to the basic rule, that is, a hearsay evidence is not admissible under the Indian Evidence Act. Now, what is res gestae? What is this doctrine? How does it come under the purview of the Indian Evidence Act, and how do courts deal with it while appreciating any kind of evidence? That is what we will be discussing in today's video. And as we proceed further, we'll know about the history of res gestae, how it originated, how it came into India, and at the end I'll tell you all the relevant cases that you need to see regarding this topic of res gestae, and that is how we will complete this whole video. Now, before that, I would like to tell you a basic thing that under Indian Evidence Act, when the courts appreciate the evidence, the basic thing that helps them in considering any kind of evidence is given under Chapter 2, Section 5 of the Indian Evidence Act 1872, which tells us that evidence can only be given of relevant facts and facts in issue. Now, in that sentence, I used the term relevant facts and facts in issue. So, before moving further, I will tell you what is a fact, how is it relevant, what is the definition of relevancy, how does a fact become relevant, and what is a fact in issue. So, let's move into the definition of those terms. Now, according to the definition of fact given under Section 3 of the Indian Evidence Act, a fact means and includes anything, state of things or relation of things capable of being perceived by the senses. And second point, any mental condition of which any person is conscious. And if we read the illustrations, it would get quite clear for you to understand what I just read. According to the illustrations, illustration A, that there are certain objects arranged in a certain order in a certain place. This is a fact. That a man heard or saw something, this is also a fact. That a man said certain words is also a fact. That a man holds a certain opinion, has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation is a fact. That a man has a certain reputation is a fact. Now, moving on to definition of relevant. One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act, relating to the relevancy of facts. Now, the concept of res gestae is also given under Chapter 3, Section 6, and the name of the Chapter 3 is Relevancy of Facts. So, under that head, you will find the concept of res gestae and all other concepts that are relating when it comes for the courts to considering any kind of evidence, whether it will be relevant regarding a case, whether it will be meant to be admissible in a particular case. That whole chapter deals with those kind of situations about how evidence is relevant and how an evidence is admissible. So, moving on to the definition of facts in issue. The expression facts in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. Explanation: whenever, under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is in fact in issue. Now I'll read the illustration for the following definition, and that will make things quite clearer for you. According to the illustration, A is accused of the murder of B, and at his trial, the following facts may be fact in issue: that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that A at the time of doing the act which caused B's death was by reason of unsoundness of mind incapable of knowing its nature. Now, I just now read the definitions of the three important terms that will help in considering the doctrine of res gestae. Facts, the relevant facts, and what are the facts in issue. Now, in general terms, when we discuss whether an accused committed some kind of offense, we usually judge him by whether he had the intention of committing that particular act, what were the reasons for him to commit those particular act, whether he was under any kind of grave or sudden provocation, whether he had any motive for the commission of any particular offense. Those acts which assert or deny all these implications are called facts in issue, in simple terms. Now, we will move further with the topic of res gestae. We will focusing on the topic of res gestae throughout this whole video. What is res gestae? We will delve into this topic further. So, stay tuned throughout this whole video. Stay focused, and I'll walk you through the whole process about how the doctrine of res gestae is made applicable into the Indian judicial system by the Indian courts while appreciating any kind of evidence. So let's begin. Now, starting with what is res gestae. So, according to the concept of res gestae is a Latin word which means things done or part of the same transaction. Now, if I have to explain only this line, I'll just say that whenever, for example, an incident is occurred in any area or any place, usually what is relevant is who committed the offense, on whom it was committed, who was the victim, what were the motives and all, what were the situations that drove the accused to commit that particular offense. All these kind of situations will be covered under the main head, that is appreciation of evidence. Now, if we will talk about where does the term res gestae comes in, how this doctrine comes into play with this whole scenario. Now, there are certain times when an incident or an offense is committed, there might be some bystanders standing during that incident across the place over that same area. They might be having some kind of discussion while that particular offense was committed. They might be saying something to each other, the bystanders. Now, everything, that is one example what res gestae deals with. I'll give you more examples as we proceed further with this video. That is just one example. Whenever an accused being committed, let's take an example. If a person stabbed B, another person, a victim, in the middle of a public road where everybody was watching, and during that whole incident, while it was occurring, all the things said or done by the bystanders also during that whole incident. Of course, the proximity of time matters, but in this case, everything said or done by the bystanders also, even though they are not directly involved in the commission of the offense, will be treated as relevant. That is what res gestae deals with briefly. Now, let's proceed further with the definition. This is the rule of law of evidence and is an exception to hearsay rule of evidence, that hearsay evidence is not admissible. I'll tell you what is hearsay evidence later on. It refers to those acts and declarations which are such an intimate part of the criminal event that their existence must be known to the court. It's a spontaneous statement made by a person just after an incident before the mind has a chance to dream up a fake story. These facts become significant in the nature of the fact in issue due to their link with the main transaction. Circumstantial facts are admitted to be part of the res gestae or original evidence of what occurred. Physical occurrences such as gestures can also be accompanied with statements. The doctrine of res gestae can be found under Section 6 of the Indian Evidence Act. Now, in this paragraph, I read about circumstantial evidence. Now, there is a leading case by the name of Sharad B.D. Chand Sharda versus State of Maharashtra, where 5 golden principles were given while considering circumstantial evidence. What is circumstantial evidence? अगर इसे हिंदी में हम कहें तो इसे कहा जाता है परिस्थिति जन साक्ष्य. When evidence doesn't directly points toward the guilt of the accused, but there are some circumstances or situations from which you can infer the guilt of the accused. Those evidences from which you infer the guilt of the accused are called circumstantial evidences. That was just to explain what is a circumstantial evidence. Now, what is a hearsay evidence? Hearsay evidence means the statement of a person who has not seen the happening of the transaction but has heard of it from others. The general rule is that hearsay evidence is not admissible in proof of a fact which has been stated by a third person. This rule has been long established as a fundamental principle in rule of evidence, but the principle of res gestae constitutes an exception to the rule of hearsay. Now we'll move on to the history of res gestae. So, res gestae generally is used to describe the circumstances in which potentially inadmissible evidence might otherwise be admitted to give context to the charged crime. The doctrine has its roots in the common law and appears to have come into common usage in the early 1800s to explain the admission into evidence of statements that were made at the time an event occurred. The justifications were that witnesses needed to include such statements to complete the telling of the story of the event itself, and that the spontaneity of such statements rendered themselves reliable. The first reference to the doctrine came by the US Supreme Court in 1817 in a decision holding that an agent's admissions against his principal are admissible when they are part of the res gestae. In 1827, the court held that the statements of co-conspirator were admissible against a defendant because they were part of the res gestae. In 1837, the US Supreme Court ventured a definition of res gestae as synonymous with surrounding circumstances. In the ensuing 100 years, the term was used to justify the admission of evidence that today is admitted as an exception to hearsay, including statements of then existing state of mind, excited utterances, the rule of completeness, and statements made by an opponent party. Now, अगर हम बात करें res gestae, how it comes and how it plays its role under the Indian Evidence Act 1872. Let's begin with that. So, the notion of res gestae is explained in section 6 of the Indian Evidence Act. In a court of law, hearsay testimony is not admissible. The exception to the hearsay rule is res gestae. The explanation for this is that such statements are so spontaneous and immediate that there is a little time for fabrication. As a result, such a declaration must be made at the same time or shortly after the conduct that comprised the offense. As I said earlier, the proximity of time matters. Whenever an incident is occurring during that time or within a close proximity of that time, if a bystander said something, I'll give you an example. If an accused kills someone and after he killed that person, he was walking through the road uttering some things to himself, and someone might have heard him uttering those things to himself. That is a very good example of res gestae. How does res gestae work? Those utterances, they are circumstantial, but they can be relevant as a part of res gestae. Let's move further. So, as per section 6 of the Indian Evidence Act 1872, relevancy of facts forming part of the same transaction. Under this section, you will not find the word res gestae anywhere written, but from this section is where the doctrine of res gestae plays its role under the Indian Evidence Act. So, the facts which, though not in issue, are so connected with the fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different time and place. Illustration to this particular section says, A is accused of the murder of B by beating him. Whatever was said or done by A or B or by the bystanders at the beating or so shortly before or after it as to form part of the transaction is a relevant fact. A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed. Troops are attacked and goals are broken open. The occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present at all of them. A sues B for a libel. Libel is a defamatory statement made by one person towards another. A sues B for a libel contained in a letter forming part of a correspondence. Letters between the parties relating to the subject out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts, though they do not contain the libel itself. Now, the principles for the admissibility of doctrine of res gestae. How res gestae is admissible? Because as I said earlier, the general rule is hearsay evidence, it's not admissible. अनुश्रुत साक्ष्य को एडमिट नहीं किया जाता किसी भी केस को कंसिडर करते टाइम. So, what are the principles necessary to make res gestae admissible? The statement must explain, elucidate or characterize the incident in some manner. यानी कि जो भी स्टेटमेंट आप रेस जस्टिस के तौर पर किसी केस में इंक्लूड कर रहे हैं, वो जो इंसिडेंट हुआ है, जो रियल के मैटर है, मान लो किसी का खून हुआ है, if somebody was murdered or if someone was kidnapped, whatever the incident was, that statement that you are forming part of res gestae must explain, elucidate or characterize the incident, not anything irrelevant to the transaction, but the actual fact in issue. The actual relevant fact should be explained, elucidated or characterized by that statement which you are treating a part of res gestae. The statement must be spontaneous or contemporaneous but not mere narrative of a completed past event. That means usually there are times when someone might be narrating the whole story, how it happened, and that raises a suspicion whether that story was fabricated or was being told to that person to say as it is in front of the court. So not to raise that kind of suspicion, the statement must be spontaneous or contemporaneous of that particular incident that occurred. Third, the statement must be a statement of fact but not a statement of opinion. The statement must have been made either by a participant in the transaction or by a person who has himself witnessed the transaction. The statement made by the bystander would be relevant only if it is shown that he was present at the time of the happening of the event and witnessed the same. Last point में अगर कोई bystander को ये प्रूव करना है कि उसने उस चीज को होते हुए देखा, कुछ बोलते हुए सुना, कुछ भी घटना को घटित होते हुए देखा, उसको पहले तो ये प्रूव करना पड़ेगा कि वो उस जगह पे था भी या नहीं. Now let's move further. What are the tests for res gestae? Now, test means how we can rely on the principle of res gestae while appreciating any kind of evidence. How much importance would be levied on this res gestae when there are other evidences, other reliable form of evidences available, and you have to consider res gestae, or if there are no other kind of reliable evidences available and you have to only consider the res gestae, the circumstantial evidences. So what are the tests for them to be so concrete that from that the guilt of the accused can be inferred, and how the courts will be able to formulate an opinion regarding the guilt of the accused by appreciating those circumstantial evidences? So the first test is cause and effect relationship. According to the first condition, if there is a cause and effect relationship or vice versa between the fact in question and the fact designed to be used as testimony, then that fact is regarded to be a part of the same transaction as the fact in question. This test, however, is useless because every event is the result of a complex interaction of numerous factors. Now, if all these causes and effects are considered relevant and evidence of all of these facts is permitted, the very purpose of limiting evidence in a court of law to relevant facts is defeated. Time proximity and location. According to the second criteria, facts connected by proximity of time and location would fall under this section. Without a doubt, events occurring at the same time and in the same place can be viewed as closely related and so significant under the provision. However, this is insufficient because the section itself contemplates the possibility of facts occurring at various times and places being linked to the fact in question and therefore becoming part of the same transaction. Third criteria, continuity of purpose and action. Third test suggests that there should be a continuity of purpose and action running through the fact in issue, and the fact of which is evidence is sought to be given. This, it is submitted, is considered equally unworthy as it merely substitutes one vague phrase for another. So, according to what we read now, every test, if it gives you a weightage as to how to appreciate a res gestae, it has its drawback also. So res gestae has to be considered very carefully. Now, at the end, I'd like to, as I told you before, I'd like to show you some case laws, some relevant case laws which deals with res gestae in our Indian judicial system, some foreign cases as well, through which the doctrine of res gestae took its place, took its roots into the Indian judicial system. All those cases you can find on your screen right now. These are all relevant cases. I have put their stories also so that it would be easier for you to assess the whole situation, that how does the courts formed an opinion and the courts were led to judge these particular cases that are in front of your screen. तो इसी के साथ हम आज का वीडियो ख़त्म करते हैं, एंड आई होप द कॉन्सेप्ट ऑफ रेस जेस्टे वुड बी क्वाइट क्लियर टू यू. अगर पूरी तरीके से नहीं तो थोड़ा बहुत ही सही, मेरे वीडियो बनाने का जो मीनिंग है वो मुझे जो है मिल जाता है. सो इसी के साथ इस वीडियो को ख़त्म करते हैं. थैंक यू फॉर वॉचिंग दिस एंड थैंक यू फॉर बीइंग पेशेंट थ्रू द होल वीडियो. स्टे ट्यून्ड फॉर मोर नॉलेज एंड सब्सक्राइब टू द चैनल. थैंक यू.